Hi everybody, welcome. Thank you so much for joining us. Happy 422, 424. We tried to make it on time, had some technical issues. Thank you for your patience. Can you all hear me okay? Give me a thumbs up. Great. I've got you guys on mute for now, and I think the way that we're gonna do this is we're gonna have you submit questions via chat, and that way we can get through as many questions as possible, and then maybe we can take some live questions at the end. So go ahead and submit your questions via chat, and then Shannon, who is right next to me, is going to be feeding me those questions. So you might hear her off camera, and she's just going to be asking me those questions. So a little introduction for those of you that don't know me. My name is Maytal Manzuri, and I'm the managing partner for Manzuri Law. And I founded the firm about 10 years ago. Our firm is specialized in cannabis and hemp business law. We mostly service businesses on the regulatory and compliance side, and also corporate and transactional side. Every vertical throughout the supply chain. We represent all of those clients. We represent brands, white labeling agreements, you name it, we've done it. In more than 10 years of cannabis, I like to say cannabis years are like dog years. So definitely got our cannabis experience and our hemp experience here. And so the purpose of today's Q&A is to go over some of the basics for the LA ordinance that just recently passed, and answer some of your questions, as many of them as I can get to. Obviously, I'm not going to have all the questions because there are some issues with vagueness in the ordinance, and it's something that DCR is actively working on and trying to amend and fix. And, it's kind of a live document. It always has been when it comes to cannabis or cannabis in LA, and, all the regulatory agencies, they're kind of adapting as we go along. So for those of you that didn't attend the last webinar or don't know much about the new ordinance, for background, for context, the major kind of things that it changed is it allows businesses to move and relocate. It allows for ownership changes and gives a little bit more details on how those ownership changes are to occur. And of course, the big, huge change was the equity share definition, and the sort of clarification still needs further clarification on what businesses need to do to satisfy the requirements for equity share. So we have 3 phases of licensing. Phase 1, existing medical marijuana dispensaries. Those do not need to qualify for social equity. They can now relocate. They can split up. A lot of existing medical marijuana dispensaries have 3 or 4 license types. Now they can relocate any of those license types. If it's one of the license types that's subject to undue concentration, they have to stay in the same community plan by and large, if their community plan has reached undue concentration. So that's retail and cultivation. So cultivation caps, we're not sure what community plans have reached their undue concentration cap, but most of them probably have, since there's 1 million square feet beyond the caps that was licensed during phase 2. So if you want to move your cultivation or your retail, it's got to be in the same community plan. Manufacturing, distribution, and delivery, once that becomes available as a standalone license, will be relocatable in any community plan anywhere in the city. Phase 2, same, you can relocate now. Phase 2 is subject to social equity. So there's 3 tiers of social equity. There's tier 1, tier 2, tier 3. Tier 3 means that you're going to be partnering with a social equity applicant or supporting them in another way. Tier 1 and Tier 2 mean that a qualifying applicant has either 51% or 33% of your business respectively. So Tier 1 is 51 and Tier 2 is 33. So that's the broad strokes. Phase 3, we had retail round 1. You had to qualify for social equity as a tier 1 or tier 2. We all know there was a bit of a scandal there. As a result, they're now going to process an additional 100 licenses during round 1. And then we've got delivery and round 2 coming up here pretty soon. Delivery, you can still be a tier 1 or a tier 2. Round 2, which is now a lottery process, you have to be a tier 1. Am I missing anything? Broad background?
I think that about covers it.
Okay, so we don't have a lot of time and there's a lot of questions, so we're gonna jump right into it. What's our first question, Shannon?
While we're on the topic of relocation, let's start there.
Okay.
Applicants want to know if we've gotten any further information from the DCR about what will happen after they've submitted their intent to relocate.
Okay, so intent to relocate, the deadline for that was July 19th. There were approximately 30 businesses that failed to file a notice of intent to relocate and currently are presumed to be abandoned, although there might be an extension granted on that from the DCR. We're waiting to hear back. For those 40 or so of you that did file a notice of intent to relocate, what's going to happen is the DCR will reach out to you and ask for your proposed address. They will either approve or deny your proposed address, and thereafter you'll have to submit a lease and a proof of deposit and then go through all the subsequent steps. Once they've approved the lease and you've paid the applicable fees, then you'll actually move and you'll build it out and you'll be subject to an inspection. Once you pass the inspection, you'll get your temporary approval. You need your state license to get your temporary approval, and then you have to pay your fees, and you should be good to go. Timeline on that is a little bit uncertain. They said before, in the next month or 2 is what DCR said. So stay tuned for that. Sometimes timelines can escape us here in Los Angeles, and we're hoping it's going to be sooner rather than later because there's a lot of people waiting on that. But essentially, with coronavirus, the DCR is, working remotely like the rest of the world. And I'm sure that slowed down their processes a bit, and they're, trying to do an overhaul of the system. So I don't know the exact timeline, but you're basically just waiting on the DCR to reach out to you to ask for your proposed address. I find that with the DCR, it's really effective to continue to reach out to them with your concerns and questions so that they can appreciate and understand the urgency of the matter. So go ahead and continue to reach out to them, email them, call them, so they know, that's how they know that something is important, is that they get the feedback from folks like you and consultants and lawyers like us who really tell them, hey, there's people waiting for you guys, so please, let's move this along.
Okay, great. For the phase 1 and 2 applicants who have already received temp approval, who want to relocate or expand, do you recommend that they start looking for new locations now?
I would say so, yes. I think especially if it's manufacturing and distribution where you can move anywhere in the city, I would suggest that you start looking for locations now. If it's for cultivation and you want to stay in the same community plan, then you could start looking for locations now. If you have hopes of moving on cultivation outside of your community plan, then you obviously have to wait and see where the caps fall for undue concentration. And the reasoning for that is obvious. Like, looking for a place is tough. You got to negotiate with the landlord. You got to find the space that's cannabis friendly. It takes time. Sometimes it can take months. Sometimes it can take weeks. So I would start looking now.
Okay. The new ordinance added in some language about, or property requirements rather, saying that any property that was the site of illegal commercial cannabis activity before an application was submitted. How do we know how the DCR is going to be looking at that, and if a property will be accepted if the illegal activity was conducted by someone other than the applicant?
Great question. So if you didn't hear the question, it's this added requirement, which was kind of there in the old ordinance, but it was expanded upon on this one, which essentially deems your location ineligible if it's been the site of prior illegal activity. So if you're relocating, I'm assuming that's going to be part of DCR's sort of green light process. So, right, if you're relocating, before you relocate, you actually have to tell the DCR that you're going to relocate and your proposed location, and then they're going to do a background check and tell you if that location flies or not. Obviously, it'd be nice if there was a central database that we could all look at to see if it had been the site of any prior illegal activity, and there really isn't. And we've asked about it, and the truth is, it's a confidential database for the police, so they won't release it. There's a couple of research tools that we use. First, we have some friends in the police department and in other areas that we can ask. But besides that, you can look on Weed Maps, Yelp. What are some other like websites where they kind of list complaints about dispensaries? You can, you can do a decent Google search to see, sometimes people have like put in complaints on a location or reports on a location to see if there's been any activity there. Also, obviously, a good relationship with the landlord, right? You can ask, the landlord should be aware of anything that's occurred there. So you want to ask him, tell him or her that it's really important that they be honest with you. And then I would build that into your lease negotiations. I would say, hey, have a clause in there that says, landlord hereby, affirms that there's been no illegal cannabis activity. And if there has been, it's a material breach and you can terminate the lease and maybe even afford damages for his lack or her lack of transparency there. So it's by no means a perfect solution, but it's all we kind of have right now. If you do enough digging, you can generally find a decent amount of information with a certain level of certainty, and then that DCR check is going to kind of give you that certainty that you want. But it's a tough one. That's a really tough one, and I don't envy those of you out there that are looking for spaces, and this is kind of an added hoop to jump through. It's makes it much more complicated.
Do you have any recommendations on where to find cannabis-friendly landlords or property owners, or any ideas of where to begin the search?
I think there are some realtors out there that this is kind of their shtick. So that's kind of who you want to go with. I know Gary's somewhere here. You can reach out to Gary. We know of a few realtors. So they kind of know they're going to help you. Doing the search on your own is going to be tough. The minute that you call and say, hey, this is about cannabis, they'll probably hang up on you. So I think a realtor will help you. I think that's probably your best bet. Now that with coronavirus, there are a lot of commercial spaces opening up. So that's one sort of benefit, I guess. Silver lining.
We have another question about expansion. What is the maximum square footage that you're allowed to expand to?
Another mistake in the ordinance. You guys, I think this is going to change. The question is about expansion. I remind me to repeat the question, but I don't, so everyone can hear it. But the question is about expansion. They added this new thing in the ordinance about that you could relocate to a space as big as you want, but your current space, you can only expand 500 square feet. That's what the rules say now. I really think those are going to change. I think that there's no policy justification behind it, and I think it was just something that was maybe an oversight or a suggestion for some reason, and I think they're kind of realizing that that wasn't really helpful. So I'm, Lord knows when it's going to change, but I think it's going to change eventually. But right now, the books say 500 square feet beyond your business premises. So it's really limiting.
Do you have any insight as to whether the 15 applicants who were bounced or skipped over in round one due to a sensitive use will be processed within the next 100, And when can we expect those invoices?
So the question was those 14 or 15 that were skipped over in the first 100, are they going to be included in the additional 100? And if so, when can we expect those invoices? I am informed and believe that they will be processed, those that were skipped over, for only the reasons of being knocked out by a competing business within 700 feet, a competing cannabis business that was invoiced, or their area reaching undue concentration. I think there's only one of those. Those folks will be processed in the additional 100. And when will they get those invoices? Soon. Soon is all I can say. I don't know how soon, but we're hoping very soon. I think, I think by the end of summer is a good bet.
Okay. Well, here's hoping.
Yeah, here's hoping for sure.
When do you think inspections will begin?
Inspections for phase 3, round 1?
Yep.
When will inspections for phase 3, round 1 be? Well, first you have to, I think it's going to be a while. I don't know the timeline, but hopefully by the end of the year.
All right. Let's see. Does the new ordinance offer any sort of priority licensing in future rounds for applicants who are not going to receive a license in phase 3, round 1?
If you applied in phase 3, round 1, and you did not get invoiced, you will be prioritized for delivery. I think that's it.
That's my understanding.
Yeah, I think it's just delivery. They initially talked about being prioritized for other license types, but I don't think that made it into the final ordinance.
Okay. We have some duplicative questions here.
Okay. Another question that I got was about changing tiers in phase 2. Can you change tiers in phase 2? Yes, maybe. So changing tiers in phase 2, if you were a tier 1 to a tier 2 or to a tier 3, it's going to depend on how you do it, and DCR has to approve it. It can be approved, but it needs to be done with some skill. Phase 3, round 1, you cannot change tiers. So if you applied as a tier 1, you are staying as a tier 1. If you applied as a tier 2, you're staying as a tier 2.
Could ownership for a phase 3, round 1 applicant be transferred to a different social equity individual applicant?
So yeah, if a social equity applicant for phase 3, round 1 wants to sell their interest, they can only sell their interest to the same social equity tier. So they have to find it. If you're tier 1, you have to find another individual that's tier 1 or another individual that's tier 2 to transfer your interest.
We have a few people in here who have reason to believe they're in the 14 or 15.
Okay.
First 100 people.
Lucky you. Yeah. Okay.
What can they do to find out whether or not they actually are one of those 14 or 15 and if they're being processed further?
Well, you have to check the question was, how do I know if I was one of the 14 or 15 that was skipped over? So in your letter of ineligibility from the DCR, it should say one of those 2 reasons. So if it says one of those 2 reasons, that's a good indication that you are one of those 14 or 15. If it doesn't say one of those 2 reasons, you're probably not one of those 14 or 15. And if you think that they made a mistake and that's the reason you were kicked out or whatever the case may be, you really just need to look at the list and do like a deep dive and figure out who was invoiced and were they within 700 feet of you, or was there another reason? So I would say your first place you look is your letter of ineligibility. You can also reach out to the DCR and ask them. They will respond eventually. Or of course you can call us and we can help you with it.
Okay, we have someone here who is changing some terms with their landlord. And they want to know if they need DCR approval before doing so.
If you want to change your terms with your landlord, do you need DCR approval? No, I don't think so. I don't know what kind of terms they're talking about.
They weren't specific.
Okay.
But do they need to notify the DCR of any changes to their lease agreement?
Nope, I don't think so. There's nothing in the ordinance that I'm aware of unless I'm missing something. I've got a bunch of lawyers in the group here, so feel free to, help me out. But I don't think there's anything. That's sort of the one thing that the ordinance is absolutely silent on is the landlord-tenant kind of relationship. The landlord just needs to approve and know of what you're doing.
Okay. Is there a fee to relocate?
Yes, there are fees for everything. There are fees for everything. There's I don't have it in front of me. I don't have the exact fee, but section 104.19 of the LA Municipal Code, chapter 10, article 4, I believe, is where the new fees live.
That was impressive.
Thanks.
If I'm a social equity applicant, can I partner with a different investor?
Great question. If I'm a social equity applicant, can I partner with a different investor? Yes. You are the social equity applicant. You are irreplaceable. Your investor is replaceable.
All right. Do we have any idea about the second social equity vetting window?
Do we have any idea about when the second social equity vetting window will open up? We have no idea. I think it's supposed to be before delivery, though. So I'm guessing timeline-wise, we're looking at processing the additional 100, then social equity, then delivery. So I would say Q1 of next year, Q2 of next year.
Okay.
And if I'm wrong on these, you guys, it's like not my fault, okay? I'm just giving you like educated guesses here.
I think that covers most of the questions we have here.
Okay.
Ownership changes. When is someone required to submit an entirely new application?
Ownership changes. You can submit a request for an ownership change. But if you're replacing, if you're being replaced 100%, if the original owners are being replaced 100%, your application will be deemed abandoned, and you'll have to file a new application.
Okay. If you were invoiced in round 1, can you also apply in round 2?
If you were invoiced in round 1, can you also apply in round 2? Yes. There is nothing in the ordinance that prohibits you from getting a license in round 2 and round 1.
Is there anything in the ordinance that prohibits you from owning 15 licenses?
Is there anything in the ordinance that prohibits you from owning 15? I think you're limited to owning 3. Right? Yeah, you're limited to owning 3 licenses. And as a management company, this was another thing I was looking at, is this year you're limited to managing 5% of licensees in the same vertical, which means for dispensaries, if we have 180 EMMDs and 100 invoiced applicants and another 100 that are going to be pending, that's 480. So 5% is like 3, less than 3. So if you're a management company, you can manage less than 3 of the same vertical. So less than 3 of the same dispensary, less than 3 of a retailer, less than 3 of a cultivation. So that's something that's interesting to keep in mind.
Okay, here's another question.
Will you remind me to find that one? So I'll email it out.
You got it. Do you do consultations, and what is the fee?
Consultations and the fee. We generally just do like a 10-minute startup call, so there's no fee. Just call our office and just based on, first we'll have to do a conflict check. And then if you pass the conflict check, then we'll do a quick 10-minute call and see if we can help you and go from there.
Okay, we need some clarification on the subject of how many or the less than 3 licenses in the same vertical. Is that for the social equity applicant, or is that for
It's across the board? The question is, about owning more than 3 licenses. I don't think it's any vertical. I'm going to correct myself. I think it's just retail. I would have to double check, but I think it's just retail. You can't be an owner of more than 3 licenses. So that means you can't have more than a 20% interest in more than 3 retail licenses in the city of LA.
Okay. Should phase 3 round 1 applicants who expect to be in the additional 100 start looking for locations, or are they going to be able to hold on to their original?
Oh, this is a good question. Is this from Kevin?
No.
Because he's asked me that question 3 times. So, the question is, if you believe you're going to be processed in the next 100 during round 1, should you be looking for other locations, or should you stay in your original location? I'm going to say it depends. You might be able to stay in your original location if the reason you were bumped out was because of undue concentration, which I think there's only 1 or maybe 2 of those so far. If you were bumped out because there's a competing business within 700 feet, then you'll probably have to move, unless for some reason that business is going to move, or I'm sure there's going to be situations where that original business is not going to stay there. But I would say, as a general rule, as broad strokes, you're going to have to move. So I would start looking. I wouldn't commit to a lease just yet. I would just kind of start warming up the landlords and seeing what works for you. You can also enter into like contingency lease agreements. So you can, if you find a space you like, you find a landlord you like, you can negotiate with him to hold the spot for you until you get the approval. That can get expensive, but there's certainty.
Okay, if they plan to look for a new location, does it have to be in the same community plan area, or can it be in any community plan that has not yet hit undue concentration?
Okay, I think we kind of answered this question. The question is, if you're looking for a new location, I'm guessing is around 1, retail, does it have to be the same community plan area, or can it be a different community? I think it has to be the same community plan area for the vast majority of applicants. Some, if your area has not reached undue concentration and another area has not reached undue concentration, there might be room for you to move in that case.
Okay, there seems to be some confusion about the deadline for phase 2 applicants to submit an intent to relocate. It seems there are some phase 3 round 1 applicants who believe they should have submitted one as well. Can you just clarify that that's not necessary for phase 3 round 1?
Okay, so the question was about the notice of intent to relocate. The notice of intent to relocate was only for phase 2 applicants, non-retail, who did not get their property inspected by July 3rd, I think. They had to file a notice of intent to relocate by July 17th. Phase 3, you did not have to file a notice of intent to relocate. You're just waiting for the DCR to send you that invoice, and then you have 10 days to go pay the invoice for the application fee.
Okay, other than state apps, what else can phase 3 round 1 invoicees be doing right now?
Other than state apps, what can phase 3 round 1 invoiced applicants be doing? You can be getting your space ready for inspection. So you can actually have the LA Fire Department or one of their, there's like fire department consultants that can come out and make sure that there's no fire issues with your location, so that you are more likely to pass inspection, because the last thing you want is for them to come out, do the inspection, for you to fail the inspection, and then for you to have to go back and do it all again. Similarly, you want to make sure that your premises diagram meets what your actual build out looks like of the space, because then you'll be a lot more likely to pass inspection. So if your premises diagram makes your store look like the Apple store and you've got an empty room, you're not going to pass inspection. So you want to make sure that that your premises diagram matches everything. And there was one other thing. Oh, you want to conduct an audit of your equity share, of your corporate agreements to make sure they comply with the equity share requirements, which is almost impossible to do right now since the equity share requirements are a little bit vague. We're in the process of conducting audits on all of our clients' paperwork and also coming up with guidelines. I'm working with the LA Bar Association. I sit on the standing committee for the Social Equity Committee, and we're working to produce guidelines to publish with the DCR on what equity share should look like. So, but there are some things you can look at your agreement and you can very obviously say that it doesn't comply. So if all the money is being funneled out to a management company, then you know it doesn't comply. There are some like really easy sort of things that you can fix in the meantime. And then if you've got some complicated corporate structure or management agreement and you're not sure if you comply with equity share, you're in the gray area, then you obviously have to wait for some further guidance or, you know, have some counsel assist you. But otherwise, if it's kind of a more simple agreement, you can kind of just look at each sort of requirement and see how you comply.
You're gonna laugh. This one is from Kevin.
Oh, hey Kevin.
Is it wise to start looking for a new location now and secure something soon, or shall we wait at this time? Will DCR give us reasonable time to find something and move?
Okay, so the question is about relocation for phase 3, round 1. If you were one of the ones skipped over or you're going to be part of the next 100 for whatever reason, is it wise to start looking for a location now? I think so. I think you can, like I said, you can always get into a contingency agreement with the landlord or just kind of do that legwork so you're ready to go. The subsequent question was like, how much time will DCR give you to find a property? I don't know honestly where their head's at with that. I think you'll have a decent amount of time, but if it were me, I wouldn't wait.
Okay. Back to management companies. What is the max management fee allowed if there is one? Is that from gross or net?
The max management fee. There's no max management fee per se as a number. It's going to be sort of like a smell test. So the standard is that the equity applicant's share is unencumbered, meaning that they're basically going home with their piece of the pie regardless. So this document that I told you guys about that we're creating together with the Bar Association and with several other attorneys, one of the recommendations that I have is that there be limitations and guidelines for management companies as to what can actually be charged. So standard overhead, rent, salary, utilities, all those kinds of basic costs obviously would be included. And then what's the consulting fee, what's the marketing fee? That's where you can kind of start to pad. And I think that's going to be a case-by-case basis, you know? If you're one of these managers that comes in and you're tripling the revenue for the space and the equity share applicant or equity individual applicant is benefiting as a result, then there's obviously a better justification for you charging that fee. But if you're obviously just funneling all the money away from the applicant as a loophole, then that's going to be problematic. The big problem is that the ordinance basically says that the equity individual applicant's only remedy is in court or by going through the DCR, but then the DCR could deem the whole license invalid. So it's not a great remedy for social equity applicants who don't have resources to sue in the first place, but that's kind of your only remedy. So Or DCR could approve, kind of review it and deny it. But it's a tricky situation. I don't have a perfect answer for you.
For PCN, can any council member in that community plan area approve a location or only locations in their portion of the community plan area?
Can you say it one more time?
For PCN, can any council member approve an application in that location or only locations in their own community plan area?
For the PCN process, this is a question about approval from your city council member. Like I said before, the approval actually has to come from all of council. It's just that your council member is the one that probably is going to make the ultimate decision. Like if they have a strong feeling, yes or no, that's probably going to carry the day. There are some community plans that actually span 2 districts. So I think like Krikorian and Rue maybe share a couple there's a couple of overlap areas. Mm-hmm. So in that case, you have your work cut out for you. You have to get both of their approvals. And then you have to get all of council to approve it.
Okay, if there is another applicant within 700 feet of an applicant who thinks they will be processed in the additional 100, would both be awarded, or would it go to the first and the other one would be bumped out with no ability to relocate?
The question is, let's say you have a community plan area, right? And you have 2 individuals that are processed within the next 100. And those 2 individuals find properties that compete with each other. Is that what the question?
Correct. Will
Okay.
the second property be able, or the second applicant rather, be able to relocate? Or are they just going to be disqualified?
Yeah, so I think what's basically going to happen is if you're one of those 2 in the same community plan, whoever stakes their claim on the first piece of property is going to be authorized first. And then the second person, because the way that I believe DCR is going to be handling it is they're not requiring you to submit a lease until they've approved the location. So basically, person A will put down, 123 Main Street, and then person B, who puts down 124 Main Street, will be told by DCR, no, that's not okay. You need to find another location.
We just got a message that says no sound. Can we just do a quick test if people can hear
Can you hear me?
Thumbs up?
Oh no, they can't hear me. Uh-oh. I wonder why.
Okay, someone else just responded and said, I can.
Okay. Guys, thumbs up if you can hear me, please.
I can hear you. Guys are great.
Oh, I hear a thumbs up. Oh, I see a thumbs up. Okay. All right, cool. Josh says thumbs up. All right.